2 minutes ago. All right, well, while we wait, we'll just go ahead and we'll just do some intros. Tell everybody who wants to get kicked off. All right, welcome everybody to another episode of the Debate Championship Series. Today we have a good one. We're going to be talking about, what is it, constitutional immunity, or immunity. I believe that's what we're talking about. I think it's Trump versus the United States in the specific case, whether or not it was ruled correctly. I'll let everybody give an intro, tell us who they are. We have some wonderful judges and then our wonderful contestants as well. We'll start with Mr. McLeod here. Go ahead.
Hi, I'm Ryan Mullally. I'm an attorney, and I'm here today to argue that Trump, the United States, was rightly decided, that it is, that in fact, the Constitution does provide for presidential immunity, and the Supreme Court was right to recognize that.
Fantastic. Thank you so much. We'll go to our other candidate next, Mr. Pisco.
Thank you, guys. Pisco, New York attorney. I'm here to argue that Trump versus the United States is a disastrous decision and that there is no basis in the Constitution for the invented immunity that the case created.
Fantastic. And we'll go to our first judge, Enemy Charlie.
Hi, I am Enemy Charlie. I know next to nothing about law. So Rich and I joked that we were like a real jury because we know nothing about law. So this will be fun. It'll just be, I guess, like most cases, kind of vibes based. We'll see how it goes.
Fantastic. Grid.
Yeah, I'm a Grid One Motorsports. I don't really have an opinion on this, so this will be really interesting to hear the various arguments put forth.
Fantastic. And last but not least, our debate coach out of Texas, Cal.
Yeah, I guess. Yeah, I'm used to judging high school kids at debate tournaments and stuff. So it'll be interesting to judge people who both have higher credentials than I have. But I guess that is what life is about, right? We live in a democracy, so we have to convince not only the experts, but we have to convince nincompoops like the three of us.
All right, fantastic. All right, well, let's kick it off then. It looks like, I believe, Mr. McLeod, you're taking the affirmative, so I guess that means you start. Whenever you're ready, I'll start the 7 minutes, and then just go ahead and take off.
Thanks, Gibbs. And yeah, just give me a shout. Just give me a shout if it looks like I'm running out of time.
Sure, I'll give you like a 1 minute and then like a half-second kind of thing.
Perfect.
Or 30-second, I mean.
Yeah. So for 234 years of American history, no president was prosecuted for their official acts. And that was a good thing. If a president were subject to prosecution by his political opponents, the moment he left office, it would chill his ability to take the bold and unhesitating action required of an independent and vigorous president. And worse, it would destroy the separation of powers and principles of limited government built into our Constitution to safeguard our liberty. Luckily, our Constitution does require that presidents have at least some degree of immunity. And the Supreme Court correctly recognized that constitutional mandate in Trump, the United States, which is the decision I'm here to talk about. So I'm here to tell you that they were right. The court was right to grant presidential immunity, despite all the crazy destiny, and maybe Pisco, we'll see, people claiming that immunity was some kind of invention of a partisan court with no basis in the Constitution. The court was right. The Constitution confers at least some level of immunity to the president, and this is the rare argument in law that's a knockdown argument, meaning there isn't really a good counter-argument. It's completely clear that the Constitution must give the president some level of immunity, and I'm going to explain that to you now. Going back to the beginning, the court was asked to decide whether the government could charge President Trump with various criminal counts. And that raised two questions. Does the president have any immunity at all? And if he does have some immunity, how does that immunity apply to the alleged facts? So I said that the first point, that he must have some immunity, is basically a slam dunk, and here's why. If you go back to your civics classes, the very basics, we have a government of limited and separated powers. Courts can't just decide whatever they want. They can only decide a case in controversy that comes before them. The president can't do whatever he wants. He can only do specific things as articulated by the Constitution. And Congress can't pass whatever law it wants. It only has powers in specific areas. And there are some areas that belong to the president and the president alone. Those are his core and exclusive powers. And his core and exclusive powers cannot be regulated by Congress. They cannot be regulated by Congress at all, because if Congress did, they would be intruding on a power that was given to only the president. So here's an example of what I'm talking about to make it more concrete. The Constitution gives the president the power to pardon. We've always known that was the president's power and the president's power alone. In the Civil War era, for example, Lincoln was going to issue pardons to anyone who defected from the South. Congress didn't like that, and they passed a law that was going to limit the scope of those pardons. And in 1870, the court ruled you can't do that. Congress cannot limit the scope of the presidential power to pardon because Congress has no power in this area. But let's say Congress got sneaky. Let's say Congress didn't pass a law that said you can't pardon. What if Congress said, I know, we'll make a law that it's a crime, it's a federal crime to do any government work on the Sabbath? They didn't mention the president, they didn't mention the pardon. Can they regulate the pardon that way? No. Because if they did, then they could still regulate the pardon. Let's say the president comes in on Sunday and he gives somebody a pardon. And then somebody charges him with that crime. They say, you broke the law. You gave a pardon on the Sabbath, and that's government business. Well, now Congress can regulate the pardon just by not mentioning it. That's not how constitutional law works. If Congress doesn't have the power, they don't have the power. So if Congress passes any law, even if it's very vague and general, even if it's a criminal law, and it tries to limit the president's ability to pardon, that law is unconstitutional as applied to the president. And that's what immunity is. Constitutional immunity is an as-applied challenge. You charge the president with a crime, he shows up in court and says, Your Honor, you can't charge me with that crime because as it is applied to me, it is unconstitutional to use the law that way. So, if you've been following along, there are certain powers that are the president's and only the president's. Power to direct his subordinates to investigate and to prosecute crimes. The power to remove executive senior officers. The power to recognize foreign governments. These are powers only given to the president. Congress can't regulate them, so Congress can't criminalize them. Therefore, the president is immune to any law that would do so. Having established that the president is entitled, in fact, to immunity, then the court was faced with a separate question, which was, how do we figure out how to apply immunity to the facts of this case? And keep in mind, the Supreme Court is not a trial court. They only get given the appellate record. Whatever happened at the district court went up to the circuit court and then comes up to the Supreme Court. They're giving a limited record. So they looked at the limited record. They looked at the scant law that talks about how to handle using legal action against a former president. And there's not much of it. Like I said, we don't generally do this to former presidents. There's a few cases that they looked at, and they determined that of the options available, they could give absolute immunity to everything, or they could rein it in and give a more limited immunity. And that's what they did. They gave a more limited immunity to things outside those core and exclusive powers. That way it could be rebutted. And then they just sent it back down to the trial court and said, look, we just told you what the law is. We told you about immunity. We told you about the rebuttable presumption. We told you about some other things that we're going to get into, but are a little too technical for the opening. But the trial court didn't consider any of that. So they asked the trial court to figure it out. And that's all the Supreme Court did. And any crazy hypotheticals or doomsaying to the contrary is just misconstruing the fact of what the Supreme Court actually ruled. We should have a lot of fun tonight. Pisco, I think I'm going to turn over to you, buddy.
Fantastic. You got 13 seconds to spare. All right, we'll just reset this, and whenever you're ready, Pisco, go ahead.
Yeah, thanks. So I take the question of whether a case was rightly decided, that what we're asking is, did the court come to the, quote, correct conclusion? Now, I'm told by originalists, and I know that Ryan is part of this originalist tribe, and to be fair, the Supreme Court has seemingly sort of accepted originalism as its main doctrine or interpretive mode of analysis. And so the question of whether something is correct is, under an originalist framework, does it provide the answer that originalists, that people who apply that originalist framework faithfully would come to, reasonable originalists would come to. And I'll note, in the entire opening of what Ryan just gave you, did he cite a single historical text or thinker or framer who thought that the words of the Constitution, I assume he's an original public meaning originalist, that the words of the Constitution meant that the president has this kind of criminal immunity? Did he cite any Federalist paper? Did he cite James Madison, Alexander Hamilton, anything? The answer is, of course he didn't. And he didn't because the historical record that we're supposed to look to as our first source, our best source for interpreting the Constitution, is totally contrary to what Ryan and what Trump was arguing for and what the Supreme Court ultimately granted. But Ryan is not alone. The majority also is bereft of the opinion, is bereft of any historical sources that suggest that the framers understood the vesting clause of Article 2, the separation of powers, to necessarily imply a type of criminal immunity. You would think that after having a revolution to overthrow a king, where the law emanated from the king, where the notion of immunity, it was the notion that God appointed the king, the divine rule of kings, that in that conversation, in the Constitutional Convention, there would be some mention of this wide sweeping, well understood version of executive power that contained with it some form of criminal immunity. But the record does not have that. If anything, right? It suggests the contrary. The framers knew how to write immunity clauses. They considered one and wrote one, a limited form of immunity clause for congressional legislators in their speeches and on their way to debates and on their ways to do stuff. There were then existing state constitutions that had state level criminal immunity for its governors and its respective state officials. They didn't write it in. They just did not. And they're smart lawyers, these guys, right? Contained within the Constitution as well is the impeachment judgment clause. What does the impeachment judgment clause say? That for basically for convictions of impeachment, which include high crimes and misdemeanors like bribery, treason, other high crimes and misdemeanors, that you would nevertheless be liable for indictment in the normal course. It was totally expected that a president at the time of the framing would be liable to such crimes, and that you wouldn't have this invented rationale from the Supreme Court that you can look, for example, Ryan brought up a bribery case. You can look at the fact that money was shifted hands. You could look at the fact that there's a bribery, but you can't look at why money was shifting hands. The essence of what bribery is, which is the right? The quid pro quo. That's what we're looking at for a crime like bribery. And obviously the Constitution explicitly anticipates those kinds of criminal prosecutions. But if you're unable to look into the evidence of whether of someone's official acts and thereby have Congress question and potentially undermine the motives behind why a president takes a particular action, then where is the room for that? Where is the room also for impeachments, right? Ryan says that Congress can't intrude on the executive branch by legislating in a way that affects the president's core and exclusive powers. Is that only for legislation? Why is it permissible for Congress to inquire as to the motives of a pardon in the context of an impeachment proceedings? Surely you would have to be committed to the position that even impeachments must stray away from going into the motives or intent behind a pardon in the context of an impeachment proceeding. So Congress should not, as a matter of, even if courts are unable to weigh on that, should not, as a matter of deference, I suppose, to what the Constitution requires, should not get evidence as to why a president who's taking bribes is giving certain pardons away. That would sort of be on the scope. But that, of course, runs into the common practice that has been established by both the court and by presidents in the past, which is even state prosecutors are able to get records. Of course, Congress can get records if it wants in terms of its impeachment matters. The truth is, there is no good historical evidence that this was what was intended. It's also, there's no evidence that it's needed. Like, look at Israel right now. Israel right now is conducting a criminal prosecution of Benjamin Netanyahu in the context of a war. And in the context of, these are just, bribery allegations, abuse of power, that kind of stuff. Are they unable to operate an executive power, an executive office? I know it's different in terms of the ministerial system, the fact that it's a parliament, but there's nothing incompatible about running a country and even having a prosecution while the commander-in-chief is a sitting president. But we don't even have that here. This is about former presidents. And it's a good thing, by the way, that the historical record is absent of any facts or circumstances that an originalist would look to imply some kind of criminal immunity, and it's a good thing that it's not necessarily entailed or even in a weaker form necessary to the executive power as understood in the United States, because it would also not be it would not be a good policy, right? I'm afraid that the president, under the current circumstance, which is counter to what most presidents assumed throughout the course of this nation's history, that they would be subject to prosecution even for official acts, potentially. I'm afraid that will lead to an unhinged executive, which is what you're seeing right now. We're seeing an executive branch that is totally unhinged in terms of their willingness to accept bribes for Qatari airplanes, to have crypto scams, to basically run roughshod over the entire executive branch, which is exactly what they're doing now. Thankfully, there is a response to the parade of horribles that Ryan is trying to cast right now, which is, if there is some congressional legislation that is incompatible with express power of the president, you can just have an as-applied challenge. But that's not what immunity means, right? Justice Barrett, she says that the term immunity, she puts it in quotes in her concurrent opinion, which I think Ryan might agree with, as a shorthand for two propositions: that the president, quote, can challenge the constitutionality of a criminal statute as applied to official acts, and that he can obtain interlocutory review. But that's just not what immunity means. If that's what Ryan means by immunity, then I guess he agrees with Barrett, but that isn't what the majority means, certainly, and it's not what most people understand immunity to mean. Thanks.
Perfect. Right at 7. I think that's the new record now. You got a record now. I'm excited. All right. Oh, we'll open it up. We're going to do about 8 minutes, and then we'll go to the judges. Fight.
Pisco, I was listening to you, and it sounds like, I don't want to put the words in your mouth, but it sounds like you're actually contesting the premise that the president has immunity as to his core and exclusive powers. Is that right?
Correct. Because I understand immunity different than you. I think that we should clarify what we mean by immunity. What do you mean by immunity?
I mean, constitutional immunity, and I do agree with Justice Barrett, is exactly what she said it was, which is, if the president is charged with a crime, the president can go to court and say, you can't prosecute me for that because that law, it might be constitutional in general, but as applied to me, that law is unconstitutional, and I'm entitled to interlocutory review. I can go up to the Supreme Court to get a decision on it. That's exactly what immunity is.
Sorry, but I don't, in abstract terms, what is immunity? Is immunity, so I'm quoting from Barrett now, that the power to challenge the constitutionality of a criminal statute as applied to official acts alleged in an indictment, and to obtain interlocutory review of the trial court's ruling. That's your understanding for what immunity is?
That's what you think. That is what the constitutional immunity is in this case. Yeah, that's exactly what it is.
No, but that's not how I understand immunity. Like, there could be a lot. So, for example, if Congress,
why does your understanding of immunity matter at all?
Well, no, I think that Black's Law Dictionary definition of immunity, that you think that matters, right? It's not just I'm not offering a proprietary definition. I think we're lawyers, right? So we're citing something. I'm about to cite you Black's Law's definition of immunity. I think that's relevant, don't you?
Well, I mean, I think the reason that this is the correct way to look at it is the question that's raised by the core powers and core and exclusive powers argument is that it's a separation of powers question. Congress doesn't have the power to regulate in these areas. Do you think Congress does have the power to regulate in these areas?
It depends. In some cases, I'm going to say no. In some cases, I'm going to say yes. But
okay, let's assume it's a core power. Let's assume it's the pardon power. Can they regulate the pardon power?
So I do actually want to get to these hypotheticals. I'm not straying away from them, but we need to have clarity on what we mean by these terms, right? Like, we need to know what you mean by immunity.
I've told you exactly what I mean. That if you bring the case against the president, he can say it is unconstitutional for you to bring that case against me because the Constitution says you can't do it. That's immunity. What's the difference?
Yes. So, because that is not the legal understanding, the typical legal understanding of what immunity is. I want to finish on that, right? Because it really matters. So if all you mean by immunity is the availability of interlocutory review and the ability to challenge the constitutionality of an indictment, I mean, that is a bizarre interpretation of what immunity means. And it's not what Black's Law Dictionary says, which is an exemption from the duties and liabilities imposed by law, meaning basically boiling down to the notion, this is in Justice Jackson's dissent, that the king can do no wrong. In other words, it's a zone where there can be no illegality. It's not the same as raising a defense. And in many different contexts, there can be separation of challenges questions where a law is unconstitutional, but that's not immunity.
It's exactly the same thing, and you're trying to make a hair's breadth difference where there is none. If the ex-president goes to court and says, you can't charge me with this crime because the Constitution doesn't let you do it. It's unconstitutional. You can call that a zone. You can call that immunity. You can call that an as-applied challenge. It's the exact same thing. He's saying the law doesn't apply to me in the way you want it to because Congress doesn't have the power to do it. And
it can result in the same situation, which is that
how are they different?
Yeah.
How is it different?
I'll explain. I'm not scared. Yeah. So they can result in the same outcome, which is that someone who's charged with the crime can have that case dismissed. But I think the core distinction here is a criminal indictment that charges some conduct will be able to inquire as to whether the president's actions were in fact unlawful or not, right? Like that's the key distinction. That's why it matters to Trump, right? That's why presumably, you can see why Trump is arguing for this, right? So if it were the case that the immunity doctrine, all it meant was a separation of powers challenge, then we would have actually the court in the ability in the driver's seat to determine whether what the president is doing is lawful or unlawful, right? So because if the president is doing something unlawful, what would the separation of powers concern with? The core distinction here, and what I think this semantical dispute is covering up, is if it were a normal separation of powers thing, the court could actually inquire into the lawfulness of it. But they can't under the current version of immunity. And,
Pisco, you are equivocating concepts in a way that I hope the judges are picking up on. You said if the conduct is unlawful, how could the conduct be unlawful if the law doesn't apply because Congress has no power in that area? And I also, just because I want to make sure that the judges are clear on this,
no equivocation.
You are taking a position that even the government, when arguing against Trump's immunity, would not take. The government conceded this point because it's so clear that there are core powers that can't be regulated. And just to make this as clear as I can,
did not concede
on page 134 of the transcript, the lawyer for the government, Mr. Durbin, said, with respect to the core powers, we think those are just things that can't be regulated at all, like the power to empower and the veto. Let me finish.
Yeah.
On that page 85, Justice Gorsuch asked him, "Did you agree that there are some core functions of the executive that a president that Congress cannot criminalize?" And he said, "Yes." Period.
So we are not. There's no disagreement that there were some acts that Congress could purport to criminalize something that the law would breach separation of powers concerns. There's absolutely zero equivocation. What we're talking about here is the concept of immunity. You said that it was equivocation for me to that I was conflating terms. Perhaps I actually don't know what the accused equivocation is, but I think I'm detecting some confusion that it somehow would be circular to have a separation of powers consideration where the court is charged with actually interpreting what is legal and what is not legal. The distinction here between calling something immunity and saying this normal separation of powers analysis is in the immunity context. There are things that the president could skate by on, in other words, not face a legal penalty for, that could be illegal, right? And that's the whole point of having the immunity, right? If the immunity is not just for things that are legal, it's also for things that are illegal. So in a normal separation of powers context, you could absolutely have some kind of determination as to whether or not the act in question or the law in question, or whether the conduct as alleged by the government is legal or illegal, if true, right? And thereby see whether it's covered by whatever sphere of incompatibility from a separation of powers.
It couldn't be. The circularity is it can't be illegal because Congress can't regulate the action. And in response to this argument, I'm going to say the exact same thing Justice Gorsuch did, which is, quote, we can call it immunity, or you can call it they just can't do that. What's the difference? It's the same thing. You're saying you are not allowed to prosecute this person in this area. And you agree you can't prosecute him in the area. And the fine line you're attempting to draw here between immunity and just the government is not allowed to do this is non-existent. The government isn't allowed to do it. Even the lawyers for the government agreed to this. Like, this is beyond dispute.
So if Congress passed a law that said something like this: it is criminal for any Department of Justice official to accept an order by the president and to carry out an order by the president to prosecute or investigate an individual in order to fraudulently undo the results of an election, would you think that law is that law would be barred? So it's not criminalizing the president's conduct; it's saying just of a Department of Justice official. Would that law be constitutional? You presumably would say no, right?
It would be unconstitutional, but not because of this case. It would be unconstitutional because of Marbury v. Madison.
Does that mean that all department officials have immunity? Is that criminal immunity? Would you call that criminal immunity?
But that's a facial challenge, not an that's a facial challenge, not an as-applied challenge.
Would you call that criminal immunity?
So the thing that
I'm asking, would you call it criminal immunity? That's all.
Pisco. No, because that law is facially unconstitutional. On its face, it is unconstitutional.
Wait,
what we're saying,
the nature of whether it's a facial or as applied challenge changes whether we should construe the kind of protection granted by the constitutional powers.
Yes, of
immunity
course.
or not immunity depends on how particular litigation proceeds.
So for the non-lawyers in the audience, a facial challenge means the law on its face is unconstitutional. Congress just can't do that to anybody. There's no world in which Congress is allowed to do what it purports to do.
But it's not immunity.
And here, yes, because immunity, as we teed up from Justice Barrett's concurrence, is not a facial challenge. It's an as-applied challenge.
Now imagine. So you know what I'm going to do next.
Let me finish the thought, Pisco. So when I'm saying that there's no difference between an as-applied challenge with a right of interlocutory appeal, and then you bring up a case of a facial challenge would be appropriate. Those are very different things. Also, the law you brought up is unconstitutional for a completely different reason. So the example doesn't really strike me as a particularly good one.
No, but hang on a second. So whether it's on all fours with the particular prosecution issue here, but now imagine the same laws at issue here targeting the Justice Department officials as such. Would you say that that would be unconstitutional, and would it be immunity? So we're not talking about the facial challenge. It's as applied. It's, conspiracy to commit fraud against the United States, but it alleges essentially the same thing as to lower officials and in the executive branch for the same conduct.
Can you go through that again? I'm not sure I understand.
I'm gonna let you go, Pisco. Then I'll give you like a 30-second response. Then we're gonna go to judges.
Okay, so here the only distinction that I'm doing in this hypothetical, again, this is about the semantics for those of you that zoom out, is semantics about what we mean by the term immunity. The only distinction, you said you wouldn't call it immunity in the law I gave because it would be a facial challenge and therefore it wouldn't be really immunity for the lower official. But now imagine, instead of this law that's very narrowly targeting these Justice Department officials, it's the same laws at issue here applying for the same conduct to those lower branch officials. Would you say that that is immunity?
Go ahead and respond, and then we're going to go to judges. Go ahead.
Of a sort, but not related to this case at all. I mean, the reason that that's unconstitutional is that in Marbury v. Madison, the seminal case in all of the federal legal system, the court decided that you cannot restrict the executive by restricting his subordinates. So, I mean, it has the fact pattern you're laying out is, yes, unconstitutional, but no, has nothing to do with the Trump immunity case. It's decided by like the most seminal case in our history.
No, but it's the same thing, right? Like the immunity at issue there, it's like just basically saying that it's incompatible. So, but you would never say, would you? Well, all these lower branch officials have immunity.
I'll let you finish real quick, and then we're gonna go to the judges real quick. Go ahead. You got like 10 seconds.
Yeah, I mean, if they had as applied immunity and an interlocutory right of appeal, I would have no problem calling that immunity. I do think they would have an as applied challenge. I don't know if they'd have an interlocutory right to appeal.
All right, cool. Let's go to Grid first. Let's ask your questions individually and then or together. Then go ahead, and then we'll go to the next judge. What you got, Grid?
Yeah, so I'm going to start with Ryan first. I'm not familiar with you. I apologize. I don't get out much. I have a question, and I'm going to probably kind of repeat this to Pisco, but it seems to me like this boils down to that. Ironically, the president has immunity no matter what, and because of impeachment and conviction, and with those two in place, that is how the president is held responsible for the things that he would do in office. And even, I believe, presidents can be impeached out of office as well. Am I correct on that?
Presidents definitely can be impeached, and that is the primary way of controlling their behavior. Whether or not a president can be impeached after he leaves office is unclear.
I know it's never been done, but in theory,
it's possible. I don't. Sure. I mean, that would have to be tested.
I understand it's never been done. I just want to clarify, as a point of law, as a point of our Constitution, and just one last thing, clarify with you. The last I checked, Congress can't change the Constitution. That's Marbury. That's what you brought up, correct? Okay.
Oh yeah.
I
So
just want to make sure.
a few very important points. When we talk about a government of limited powers, that you are 100% right. Congress cannot change the Constitution on its own. It would have to go through the amendment clause, which requires a supermajority. It requires ratification by the states. It's a really onerous process. And that's really important because separating the powers and limiting the powers is how we prevent any branch of government from becoming tyrannical. So when I say Congress can't do this, and when I say that that defends our liberty, what I mean is whenever a branch of government attempts to escape the boundaries of the Constitution and do something the Constitution would not let it do, that is an affront against the protections that protect our liberty. And that's why, even if in a particular case, and I don't know you guys, maybe you're Trump supporters, maybe you're not, I don't know. But if you whatever you think of the outcome of this particular case, we're trying to create an enduring system that will last and will protect our liberty regardless of who's president. And letting Congress do something it's not allowed to do cuts strongly against that protection.
Gotcha. All right, Pisco, just a couple of questions for you as well,
Yeah.
and I'll try and be really quick because I know Charlie wants to go. Assuming that Trump doesn't have immunity in these cases, what mechanism is there to prevent any president from being taken to task via lawfare from here on out, including their entire cabinets and everything else? So it seems like that what you're basically saying is there are all of the protections for this executive doing his job are now gone, and he must now live in fear of Congress and lawfare, and that seems to be where you're going. I just want to be clear.
Yeah, so I would say, first of all, it's assuming a lot to think that this immunity would protect other cabinet officials from bad faith lawfare. The reason I pushed that,
I didn't say cabinet. Well, I did say cabinet officials, but really I was talking about the president. I'm sorry,
okay.
I did throw that.
But I want to dwell there just for a second, because the reason I was pressing Ryan on that, with purposes of understanding what he means by the term immunity, because really, if you take a look at if all you mean by immunity is an ability to bring a separation of challenges, separation of powers challenge and interlocutory review, then presumably that would also be for lower executive branch officials. But the opinion seems to proclaim that it's only the president who gets this authority, and also, but I don't understand why, if also going along the same notion, and I promise then I'll get to the thrust of your question, that if the executive branch, if it's just a unitary executive and all power emanates from the president himself, I'm not sure actually why the logic of this opinion doesn't extend to all lower branch executive officials and Department of Justice officials. So I think your question is a good one, but it's presuming that the court would be consistent. I think to be consistent, that it would have to apply to lower executive branch officials if you're taking them at their word that the executive branch is a branch unto itself in only the hands of the president. But your question is basically what prevents kind of bad faith lawfare. I would tell you that the thing that prevents the bad faith lawfare is the same thing that prevents it as to everyone else, which is Article 3 courts. It is unconstitutional to have political prosecutions. That is against the Constitution. You have the amazing criminal procedural protections of the Constitution, which people like Justice Scalia, another originalist, defended and has defended in the past. Those protect us from bad faith and malicious prosecutions. You have, again, an entire history where, yeah, it's not typical to go after presidents for past conduct while in office. And that can either lead you to one of two conclusions: that Trump is an especially onerous individual, and he is, that would be my conclusion, that did crimes to try to insert himself in office and to maintain power, which is what the complaint alleges, and that everyone else was able to operate, even if you think that this was as originally intended. It certainly wasn't what most people thought. Most people thought throughout the course of the centuries that the president was liable to this kind of indictment, and it protected us for this long. And so I have no reason to think that the courts can't handle these kinds of bad faith situations. A lot of times these prosecutions, even in the Trump case, right, are backfire on the people bringing them. In some ways, you can say that the charges brought in New York backfired on the Democrats. Now, I'm not saying that it was a political prosecution there, but if you were just thinking in terms of pure power politics, Trump's numbers rose substantially after the New York indictments, and the same thing with like the impeachment of Bill Clinton. And so I'm not sure that the current kind of norms in terms of political prosecutions, in terms of it being a public issue, and in terms of the courts, they're plenty sufficient. What we can't handle, though, is the president using his official powers to try to steal an election. That's what we can't handle.
Okay, so great, and I'm sorry I didn't realize you were going to take that long, so I'll just do this one last question. You keep talking. You brought up impeachment and the fact that you understand immunity differently. But I don't see that you're actually understanding immunity differently. You're just trying to ignore the fact that impeachment holds the president accountable, and that is the correct method for prosecuting a president. That's my understanding. Maybe I'm wrong about that. If you could clarify, that'd be great.
No, it's a great question, because look at the words Ryan used. Ryan didn't say Congress cannot with respect to legislation. He said categorically, and so does the court, by the way, he's not alone, that Congress cannot touch these powers. In other words, just like with respect to legislation, Congress trying to legislate to affect these powers, why would it be acceptable for Congress to initiate impeachment proceedings on a power that's in the exclusive and conclusive prerogative of the President of the United States? So I'll give you the following example, right? If you were to have an impeachment proceedings of a typical bribery, right? So what we have here is evidence of money being transferred to the president in exchange for a pardon. Everyone agrees, right? Like that is impeachable, right? Well, what the Supreme Court tells us in this context is you can't actually introduce the evidence of the pro for the purpose of showing that the pardon was given for the exchange of money, which is totally fucking bizarre, totally absurd as a ruling. So why would it be okay for an impeachment proceeding to inquire into the motives of a pardon, but a criminal prosecution not to inquire into the motives of a pardon, if both are Congress acting in such a way to, again, inquire into the motives of the president's use of his conclusive and preclusive authorities? That's why impeachment is relevant, in addition to the impeachment judgment clause reason that I cited at the start of my talk there. But yeah.
All right, let's go to Charlie.
Lord have mercy. Rich, do you want to go first?
We go to Rich.
Yeah, I have some questions.
Okay.
Two lawyers, I'm so sorry.
I have some quick ones, but I have one that's like foundational for me, like that's critical in the round for me. I guess I'll start with the critical one, because Pisco started with a pretty good observation, which is that there wasn't a reference to the Constitution or to like any founders to sort of give us philosophically how we're supposed to interpret parts of the Constitution to make this argument. But then, to my point of view, Pisco commits the same sin. I'm not hearing this in academic debate. We call this link level analysis, and I don't see a link to where this immunity either comes from or the authority to prosecute the president comes from. I haven't heard any reference to the Constitution. So far, the only two things I've heard that are external things that I can like sort of look up and read if I wanted to was Barrett's analysis in the recent case and Marbury versus Madison. But I haven't heard like any like what portions of the Constitution either grant this immunity or grant like the power to check the executive in both directions, because I haven't heard that from either debater.
What do you want to start with, Ryan?
If you don't mind, I have the affirmative, so maybe it's easier. A few points in no particular order. The first is there's plenty in the Constitution that hooks into this analysis. And if you look at the Supreme Court decision and read the main opinion, you'll see all the things that I've been pointing to. So the Supreme Court expressly calls out the structure of the Constitution. They point to Article 1, they point to Article 2, and the limited and separate powers given to each branch of the government. Then they point out that certain powers, and a great example that I referenced earlier, the pardon power, is given to the president, and Congress has nothing to say about it. And then they give the example from 1870, where Congress tried to restrict Lincoln's ability to use the pardon, and the Supreme Court in 1870 correctly ruled that Congress lacked the power to restrict Lincoln's use of the pardon because that is a power that is exclusive to the president. Now, Pisco talked about history and statements of the founders because he knows I am an originalist, and that's, if I were writing the decision, that's the sort of thing that would appeal to me. But it's worth remembering that Justice Roberts is not an originalist, and he's the one who wrote the decision. So I don't think Pisco would say that one must have an originalist framework in order to have a good legal decision. I would assume Pisco would actually disagree with that because he's not an originalist, but he can let us know when it's his turn. That said, there is history that points towards this. Ben Franklin at the Constitutional Convention decried the idea of prosecuting the executive for fear of what it would do and called into mind the fact that whenever it's happened historically, it's been a disaster. Marbury versus Madison, which is, like I said, it's an 1803, 06, I can't quite remember, 03 maybe, case. It's the most important case in the history of our country.
Created judicial review, yeah.
Yeah, it created judicial review, said, by the Constitution of the United States, the president is invested with certain important political powers in the exercise of which he is to use his own discretion and is accountable only to his country in his political character and to his conscience. So this is not ahistoric. This is absolutely how this has always been understood to work when you look at how the law was actually written. The reason there's confusion around this is that there are things for which the president is not immune. For example, if the president left the Oval Office and went to Starbucks and just slapped a barista for no reason, that he's not acting as the president. That is outside his official capacity. He has no immunity based on the Constitution for that action. So just because he's the president doesn't make him immune. What makes the immunity comes from the separation of powers and the delineation of certain powers exclusively to the president, which Congress has no power to regulate, as the government, even in this case, admitted.
Okay, so that gets me to just a quick question, just to follow up on that, because like we have 3 levels of analysis that come out of that recent decision, right? We have absolute immunity, presumptive, and then no immunity at all, right? So what I'm interested in is the Justice Department's understanding of this right now, because it looks like the Justice Department seems to think that they can investigate Obama for what they perceive to be crimes, which presumably they don't believe he's immune to.
I mean, I think they are probably, I have not looked into that deeply, but my strong suspicion is that they are wrong. And that if they attempt to bring any criminal charges, Obama will raise an immunity defense and will win. That's my guess.
Cox, right? And so was Archibald Cox, wasn't he?
Can you give more color?
Special prosecutor in the Watergate matter, when he was investigating obstruction of justice of Richard Nixon, he was wrong.
I think the question there is going to be somewhat different. And the reason is there's tons of stuff that this court didn't decide. It decided only the case that was in front of it. I don't know.
The removal of they cite as one of the core exclusive powers. This is 5 justices signed on to this, is the removal authority of the president, citing Myers and other cases. Under that framework, the notion that President Nixon could be criminally held liable for firing or obstructing justice in some way by ordering around his FBI or getting the CIA to alter evidence or to lie, I mean, that must be beyond the authority for the special prosecutor in that case to prosecute.
Probably. I mean, I don't know because I haven't seen the facts as applied, but it sounds reasonable to me that probably there should have been immunity there. That said, one of the great wisdoms in our country was pardoning Nixon. Because he was pardoned, this question was never asked. And the thing in law is sometimes when you ask a question, you get the answer.
Yeah, but that's not
we don't know whether Nixon had immunity. Well,
we're not debating policy.
I'm explaining that the reason we don't know whether Nixon would have had immunity under the same analysis is that the question was never asked because a pardon was given. That's why we don't know. They never went to the court.
Is that relevant to anything? I mean, the question, what I'm asking you basically is, under your theory of this case, the notion that Nixon could be held liable for like ordering his FBI to lie to Congress, ordering his FBI to like hide evidence, to break into people's homes, right? The real problem, potentially where Nixon maybe could be found liable, but although there's limited evidence on this, is I guess if he ordered private actors to bug the Watergate. What he should be doing is using the FBI to bug the Watergate. And basically, you're saying if he did order the FBI to wiretap illegally, purposely, the Watergate for political purposes, or to fire people, or to obstruct justice in other ways by like hiding evidence, destroying evidence, that would be beyond the reach of criminal law. I mean, that is what you're saying, right?
There's a million ways that the court could reach a different outcome, but I don't know the facts well enough to give you an answer on that. Let me give you an example. In the Trump case, they made clear that somebody acting as a presidential candidate is not acting within their official capacities, whereas when they act as president, they're in their official capacities. So
order the FBI.
If Nixon gives an order to a PI to bug someone, which is I think one of the examples you said, that he very well might not be in his official capacity.
I said the FBI.
And talking to the FBI, more likely he's in his official capacity, yes.
Yeah.
But this was not before the court, and we actually don't know a lot about this because the court remanded because it needs more factual development. If, God forbid, there are more cases on immunity, we might learn, but hopefully we never do.
Yeah, but under that framework, I'm not sure why it would be acceptable for, like, let's say Congress issues a subpoena for impeachment, right? A subpoena for impeachment to get some information or documents. So they're saying, we're issuing the subpoena because we want to investigate whether President Nixon or President Trump obstructed justice by firing Mueller or by, issuing a directive to his FBI director to delete evidence. Like, the court should say, Congress can't do this. Congress can't base its subpoena, a legislative subpoena, on trying to inquire as to the motives about why the president pardoned someone. But then we have U.S. versus Nixon. And so this runs right into our prior precedent on the Supreme Court's precedent on the investigations and subpoena stuff. And so I just don't understand how that's like this wouldn't encourage, if we're doing the policy stuff, the worst kinds of bad
action. You got another question here, then we're going to go Charlie just for a second time.
There's a through line, right, to Nixon in all of this anyway, because we know that, like, we have people like Roger Stone who come out of the Nixon administration who understand the mindset and tried to put that mindset into the Trump administration. And, Nixon himself, when he was interviewed by Frost, sort of famously says that if the president does it, that means it's not illegal. And I've got to think that
he was right about that.
I'm sorry?
That he was right about that?
Well, that's part of what we're here to determine, right? So,
yeah. I think he was wrong about this because you asked me a question, but like, sure, where's the history for my side, right? Like, where's the history that this can happen?
Right. That's exactly what I want.
Right. So first, I would start by saying, there's a bunch of canons of construction of constitutional interpretation. I would say expressio unius est exclusio alterius. The fact that, in other words, this is Latin. The fact that you text me that way. Do you want me to send it to it? It's expressio unius est exclusio alterius. You can just Google it. It's spelled the normal way. Basically, if a law specifies some items,
it normal Latin,
it suggests that the other stuff, the other things that fall within those same categories, aren't included. So, for example, the fact that the Constitutional Convention created legislative immunity, that would seem to suggest, wouldn't it, that they didn't intend to include presidential immunity. The fact that and one more thing. And the fact that they weren't thinking of immunity and they didn't have statements about immunity. The Franklin one is distinguishable for other reasons. And there's other statements as well, I think, that suggest that he is liable, including the impeachment judgment clause, which I cited before, which seems to anticipate these kinds of prosecutions, specifically inquiring into the motives of the president as official actions in the example of a bribery case. But the fact that they aren't thinking potentially, if it's true that they didn't have these long conversations about whether or not there's criminal immunity, would seem that there could not be logically an original public meaning, a public understanding that the executive branch wanted this to exist, right? So Ryan starts his whole thing by saying the government is a government of limited powers. That's how he started his entire conversation. If it wasn't in the mind of the original public, right? Not just Ben Franklin, but the public, if it wasn't in their minds to have this kind of criminal immunity, then by definition, it wouldn't exist.
Let's go to...
I'm not hearing these foundational links yet from either side. I do hear from from the what I regard as the affirmative side, which is the first speaker, I hear this like the only concrete thing that I've heard is the pardon power, which I understand. Like I'm totally convinced that the president's pardon power cannot be questioned because it's explicitly spelled out in the Constitution. But the only other thing I hear is that it's in Article 1 and 2.
Wait. There are a lot of powers in that given to the president, including he's the commander of the armed forces. Right. So presumably, if no one else can command the armed forces but the president is the sole and exclusive commander of the armed forces. So I'm going to give it to you, and I'm going to give it to Ryan. The commander of the armed forces of the United States orders the military to enter into the Capitol and arrest every single senator and congressperson. Is that under the ambit of this immunity?
So the clear answer is that we don't know. And the reason we don't know is that the court in no way, shape, or form ruled on whether or not the president has a core and exclusive power in that area. It's just not part of the case. You can go in and Google it. It's not part of the case.
It's an official action, though, right? I understand
it's not. It's an official action, but that does not mean
it's entitled to at least presumptive immunity, right?
At least presumptive immunity.
At least presumptive immunity.
But we're getting into deep waters that we have not explained to the judges yet. So just flagging that, just so if we're going to go there. So the first point is it's not part of the case. So if it was part of the case, the court would have ruled on it and I would have a better answer. It wasn't, so I don't.
But there's not a good answer. There's not a good answer.
The next issue is, sorry, I apologize. You say there's no good answer to that?
There is no good answer to that. That's right. The only answer is that yes. The answer was given, actually. I mean, you cited the oral arguments. Trump's lawyer said under the Fitzgerald test, which is the test that the court adopted, right? The court did adopt the Fitzgerald test. They came to the answer, which is it is an official action. And under the official action, I mean, that test is incredibly, that even if you were, I think this is all core, right? Ordering the military, like imagine it, right? That during the Confederacy, during the Civil War, that the Confederates took over Congress. What, you're going to question Lincoln sending in troops into Congress for the purpose of liberating it? Again, you can't inquire into the motive of how the official power is used. And the court starts by that, saying you can't look into the motive. You can't conflate the power itself with why you would invoke the power. So you can't look into why they're doing something in order to determine whether it's an official action. So in the case that I present, which is the commander-in-chief ordering a military coup, you can't look into why they're doing it. They're just ordering a bunch of troops to arrest some people in the Congress. And in that case, right, what the court had adopted was the Fitzgerald test. And that's obviously official action. And you just said it's official. And so the only defense we have to a military coup, criminal prosecution to a military coup, is this at least, it's not total presumptive, it's at least presumptive immunity. It might be absolute immunity, but at least presumptive immunity. And in this case, it would be so simple to have an argument. This is not at all, going to be covered by the small little narrow section that presumptive immunity seems to anticipate.
So Pisco jumps the shark in a few ways here. Oh, sorry.
I'll give you like 10 seconds to respond real quick, but then we're going to go to Charlie just for the sake of time. Go ahead.
10 seconds? Okay, that's a lot to respond to in 10 seconds.
Okay, yeah, you got 10.
I think the most important thing to realize is that we're talking about prosecutions of the president after the fact. So if the president did a coup, prosecutions after the fact aren't protecting you from anything, to be totally clear. It wouldn't matter. That's what a coup is. But in the example that Pisco gives, he's closing his eyes to the reality of how the justice system works. This issue was not decided. And if Pisco thinks that a president could use the military against Washington, D.C., commit treason, attack his own country, and then skip off to Russia and say, I did it for Putin, now I'm a Russian oligarch, ha, 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 and that later on we catch him and prosecute him, and the court's not going to inquire into that and say, maybe that's not, maybe what you did right there was outside your role as the president, you've lost your mind. But we don't know because that wasn't part of the case.
No, so it's not the commander-in-chief power in the context of, I want to let the other just talk, but he is accused of using the trappings of his office to try to overturn the election. So you're saying it's so fucking ridiculous that he would do something like this. He did it in a more procedural fashion, no doubt. He didn't use the military, but that's essentially the fact pattern of the allegations in the Washington, D.C. case.
They are not essentially the same. A military coup is not at all what was raised in this decision. You're out of your mind.
No, we're talking about core official powers, and it is a core official power of the president to be the commander in chief. If President
we do not know that. We do not know that. It really might be.
Let me just a little. All right, we're gonna go, Charlie. Charlie, you got questions? I got questions, but I'm just letting you ask the questions.
Okay. I'll be honest with you. This has been incredibly complicated.
Yeah.
If there's steam coming out of my ears, wheels are turning. Well, I mean, Ryan, and Pisco, if Trump were to do the hypothetical scenario that you presented, Ryan, if he were to do crazy stuff, then go off to Russia to be a aristocrat or whatever, would it not be possible if we were to bring him back and try to prosecute him? Would it not be possible for whatever attorneys defending him to say, no, look, he had criminal immunity? Like, would this not be an argument that someone could make?
Yes, I would.
That could complicate legal proceedings.
It absolutely is an argument they could make. It is an argument they would lose, I think,
would
but
you,
it is an
Where would
argument
you
they would
stand?
make.
Because
What
it's
position
my
would you have,
again,
Ryan?
I'm not a again not a law person, but is that not what the issue is? Is that we are giving presidents criminal immunity after they leave office, and they cannot be persecuted for any acts that they, committed in an official capacity.
Yeah, no, you're right.
So I feel like we're kind of in the danger zone there, because also, Ryan, you brought up impeachment, but I had to double check on Bill Clinton. I was 1 year old when he was impeached, or he wasn't impeached, almost.
He was impeached.
Oh, he was? Oh,
He was,
okay.
Yeah.
He was not convicted.
Yeah.
Oh, yeah, he was not convicted. He was impeached. But it doesn't seem that impeachment is a very effective process at the end of the day, because it doesn't seem like any president that has been impeached has been forced to leave office. It just feels like again, maybe that we are in fact giving presidents too much leeway to kind of do whatever they want if they're acting in an official capacity without any sort of being held responsible.
I know that we've been going very long, so I'll try to be brief in responding to that.
Mhm.
The first point is that impeachment is the primary method for corralling a president. It's a political process, and it's a tough political process. So you're right, it's tough. It should be tough. The president was elected. We shouldn't be able to kick him out of office willy-nilly. We don't know what effect impeachment would have on immunity. At oral argument in this case, both sides agreed that if you impeached a president, he would lose immunity and you could prosecute him afterwards. Is that something that we will find out? We don't know. It didn't happen in this case, but at oral argument, both attorneys seem to think that was right. And then as to the last part, and I just want to stress this because it is important, we're starting to talk about policy, which is interesting, and I'm happy to talk about it if it's interesting to the judges. But I want to stress that policy only matters when the Constitution isn't clear. If we're trying to decide what do you and I think is best, that's one question. But here, the Constitution expressly limits Congress's power and expressly gives certain powers exclusively to the president. So since the Constitution is clear, what we think of the policy behind it doesn't matter that much. Like that's what Constitution is. It's there to be the law regardless of what we think of it policy-wise. And I'm yet to hear any reason why Congress should be able to regulate and therefore criminalize the president's core and exclusive powers. And I don't think one will be provided, because every lawyer who worked on this case, including the people trying to prosecute Trump, thought it couldn't work that way.
I want to first respond to the notion that the opinion doesn't deal with the effects of impeachment on immunity. Of course it does. It says there's no relation. There's no relation between the impeachment judgment clause and impeachment generally and what you're liable to be prosecuted for. That's why the textual argument from the impeachment judgment clause in favor of my position is so strong, because it would seem to indicate that, yes, and that's why this case is so fucked. Sorry, excuse my French, because they gave him more immunity than he asked for. I mean, even the Trump attorneys, right, the litigants here, they seem to suggest that you could prosecute Trump for official actions after he's been removed from office. But the Supreme Court is clear in the majority opinion that the impeachment judgment clause has no effect on whether or not you have criminal immunity. And of course, that makes sense given their logic. Their logic is that the threat of criminal prosecution would unduly chill a president. Well, that threat exists if you have a carve out in the impeachment judgment clause, and if you take a purposivist and policy-oriented argument, as the majority did in this case, then of course that incentive structure exists if you have a carve out for official act prosecutions after an impeachment. You would still have the threat of prosecution for your official acts if all you needed as a procedural step is to require impeachment. So they have definitively asked that. I want to address something else that Ryan said, that like, oh, this doesn't protect you because it only applies to a former president, so you wouldn't have the power of the prosecution during a current. Well, my gosh, we do have this notion of deterrence. You know, most criminal law, one of the big basic precepts of criminal law, why we even have criminal law in the first place, is because it deters action. Why are people upset when like San Francisco decriminalizes? That's a lie, but lowers the penalty for certain crimes or changes what's criminal? Is because they're afraid of the deterrent effect. So of course, having a criminal punishment taken away, potential criminal punishment taken away, is going to lower the amount of deterrence for a criminally oriented president. And it's exactly what you're seeing right now. You're seeing bribes up the wazoo, incredibly corrupt shit happening every single day by the administration. The actual reality is totally what you would expect. Totally what you would expect given the ruling here. And finally, just on this notion of the hypothetical as presented, we can move off the hypothetical if you want to go back to the base of the opinion. I have a question for Ryan. Where would you be if the case that you presented just there of someone running off to Russia after trying to do a military coup and failing, would you be arguing that they had criminal immunity? And what would your argument be, if so?
No, I don't think they would have immunity. Before we get into that, I think you misspoke about something and just want to make sure that we're on the same page. You said that impeachment has no relation. The majority said that impeachment had no relation to immunity. What the majority did is they rejected the argument that you had to impeach prior to prosecution, and that it was a necessary condition. It was a gateway. They rejected that argument. I agree with you. What they did not rule on, and I would be surprised if you could find me anything in the opinion that speaks to this, because I'm 99% sure they didn't. They did not rule on whether a successful impeachment plus conviction strips a former president of immunity, which was an issue raised at oral argument. They didn't have to decide it because it wasn't in the case. So of course they didn't decide it, but they did not rule that out.
Why would Congress be able to, but think about the logic of the opinion. Why would Congress be able to regulate the president's official conduct after an impeachment? Like, Congress acting through impeachment and acting through legislation is still Congress acting. How can, if it's all about separation of powers, how can Congress achieve what you say they can't by separation of powers bases achieve through legislation through impeachment? Make that make sense.
Because clear Supreme Court case law says that the impeachment process is a political process that is designated to Congress that the courts have no role in.
Oh, no,
so
I mean,
Congress
that's whether it's a political question. That doesn't resolve the actual question.
That's exactly the question here. Because if you went to court and you said, court, you must stop Congress from impeaching this president because of your decision in Trump, they're going to say, you're out of your mind. That's a political process that you have nothing to do with.
I'm going to let you respond, Pisco, and then we're going to go to Charlie again. Go ahead.
So you're saying it's okay for a Congress to impeach a president based on his official and look into the motives of his official conduct. You're saying that's okay?
Am I answering, Gibbs? I don't. What's the?
Yeah. Go ahead, answer. Yeah, like 20 seconds.
I don't.
Gibbs, I have no more questions.
All right,
Gibbs.
all right. We're just gonna go back to open real quick for the second time. Then you can start us off.
So the question,
Ryan.
repeat it again for the audience. The question is, because there seems to be a notion of separation of powers, that Congress can't touch the core and inclusive powers of the president. So the question I present to Congress through legislation: can Congress inquire into the motive of a president's core and exclusive powers through the procedure of impeachment? That's the
there's no one to stop them. The impeachment power is a political power that's been delegated to Congress. The courts have been totally clear that they are not going to look into and supervise why Congress impeaches someone at all. That's not something they're going to look into. So
you the constitutional question. I'm asking you not.
I'm answering the constitutional question.
No, but that's a political question. I'm saying the courts can't. So the difference for the audience, right? The political question doctrine is: can a court resolve an issue? But that doesn't resolve whether it's unconstitutional. Someone could still stand up in Congress and say, my fellow senators, we have this precedent of Trump versus the United States. It is for us to follow the Constitution, right? The senators swear the same oath to the Constitution as all the justices. So I'm not asking whether the courts could resolve it. Would, in your mind, it be constitutional for Congress to do an impeachment when they're inquiring into the motives behind their core and exclusive powers of the executive. That's the question. Not whether it's
Yes,
lawful or
because
court.
Congress is the only branch of government that is entitled to decide what is appropriate in that context.
So any impeachment is constitutional. Is that what you're saying?
Yeah, I don't see any basis why a court could undo an impeachment or say it's inappropriate.
I'm not asking whether the court could.
Yeah.
You're saying that all impeachments, even for things that aren't high crimes and misdemeanors, are constitutional.
I'm saying there's no body that
That's
which
not
you
what
can
I'm
challenge
asking.
that. So yes, it is up to Congress. If
I
they
want you
say
to
it's
say-
constitutional, then it's constitutional.
No, I want you to acknowledge that there have to be some if an impeachment, if they say this is an impeachment that's not based on any high crime or misdemeanor or treason or bribery, we just want to get him out because we don't like how he looks. That would be an unconstitutional impeachment, wouldn't it? Come on.
No, not if they have the
No?
votes. If they can get that through the House and that through the Senate, then yeah, they can impeach somebody for having a ham sandwich. There's no limitation on that power.
So Congress decides what's a constitutional Congress. So you're saying that there is no self-standing constitutional standard that Congress should adhere to, right? The Congress has no obligation to follow some standard.
It's Congress's.
I'm sorry to interrupt, but doesn't the Chief Justice run the trial in the Senate?
As a ministerial, I mean,
He does, but he doesn't have any real power.
right, yeah, and
Okay,
Chief
fair enough.
Justice Roberts. I think
It's a good point, though. It's a good point.
Yeah. No, but I just want to be clear about something. Obviously, right? The Constitution says Congress may impeach for a high crime or misdemeanor. That's what it says. And obviously, Congress has an obligation to follow that. Now, it's true, right, that the courts can't determine whether or not a high crime or misdemeanor occurred, but Congress is bound by that. And if Congress all decided, hey, we're just going to impeach this guy because we don't like it, of course that would be unconstitutional. Now, a court couldn't resolve that, but it would be unconstitutional. And your unwillingness to give that up, I mean, that's ridiculous.
Pisco, there are 3 branches of government, right? They're the ones that decide what are constitutional. That's how it works. The courts, you've admitted, aren't going to do it. Congress wants to do it. That's why they have a supermajority in the House and the Senate and we're able to convict. The president doesn't get a say because he's the one being impeached. So, yes, in the scenario you are outlining, what is constitutional is determined by Congress. They are the only branch of government empowered to make that determination.
I truly, so anything that's a political question, you think, there's not a constitutional dimension to it that can be analyzed from an.
There is a constitutional dimension. The decision is
Congress
allocated.
The impeachment can be totally spurious. The impeachment can be totally devoid from law in that sense. Barring the procedural elements, which I think probably a court would decide to rule on, right? Like I think a court would decide, like, did you even have a supermajority?
Yeah, I think that's sort of thing they would. Yeah, we agree on that.
So I think that there's probably some role there. But in terms of the substance there, I mean, man, dude, like Congress has a self-standing requirement, obligation to follow the Constitution. It is insane to me that you would say that no impeachment, no matter how bizarre, no matter how explicit they are, we are doing this even though the Constitution forbids it, right? They even put that there. We don't give a fuck about the Constitution. We are just impeaching him because we can. And you would say that is totally constitutional to do. That is ridiculous. That's not how our Constitution works. The Constitution, yeah, different branches have different roles in interpreting it, but everyone has an obligation to follow the Constitution. And what you sound like is kind of like a purposivist who's like living Constitution. The Constitution means whatever Congress says it means.
What Pisco consistently tries to get around in this argument, and he has to try to get around it because it's crushing for his position, is that the structure of the Constitution is what determines what is constitutional and what is not in many cases. Like, for example, there's canon Supreme Court law that says just because the Constitution doesn't say the word presidential immunity, you can't control F it, that doesn't mean there's no immunity. The court decided that in the Nixon era. And they decided that because the structure of the Constitution is itself part of the Constitution.
Fitzgerald was wrongly decided.
So this case was wrong. Wait, hold on. How many Supreme Court cases do you, Pisco, junior attorney, think that you are in charge of saying what's wrongly decided?
First of all, so you agreed with Dobbs, didn't you? You have no problem overturning cases that are wrongly decided. Fitzgerald has invented civil immunity that doesn't exist anywhere in the Constitution as well. So let's not pretend that this court cares about respecting stare decisis and precedent. I think one of the big mistakes, as is recognized, by the way, not just me, dipshit, but also people like Akhil Amar. Do you respect Akhil Amar?
I don't even know who Kilmar is. Go ahead.
Constitutional scholar. I mean, there are constitutional scholars who raise the position, so don't try your demeaning bullshit. Say that Nixon versus Fitzgerald was wrongly decided. I think it was wrongly decided. It's also not necessary. You don't have to apply Nixon versus Fitzgerald to the criminal context. But there is no place in the Constitution that says, oh, you absolutely need civil immunity, or civil immunity was understood at the time of the founding of the Constitution that we'd have this kind of doctrine of civil immunity. I mean, let's be honest about that. It's not there. The text is not there.
Again, the reason that Pisco is harping on whether you can control F presidential immunity, which we all know you can't, even though he's read other Supreme Court case that says that doesn't matter, but he says that case is wrong too. And the reason he's harping on policy is because the core argument, which is about the structure of the Constitution, he has no response to.
No, there's a
response. He has, what is your response to the argument that there actually that there are core and exclusive powers that Congress
I'm gonna let Pisco respond, and then we're gonna judge again for one question each. Go ahead, Pisco.
There is absolutely a response. The notion is that the structure of the Constitution does not require it, that there's nothing necessary about having personal immunity, that all you need are normal separation of powers checks. Now, if he defines immunity to mean normal separation of powers checks plus interlocutory review, he's just redefined what immunity is. That's what we were talking about in the very first section. And so if that's what you mean by immunity, then okay, but that's not what people mean by immunity. And so normal separation of powers concerns are fine to deal with, like inherent conflicts between the law or its application and the core executive powers that you're talking about, or just the president's powers in general. So there's a response, but there's no logical necessary implication into having this kind of wide sweeping criminal immunity, and there's no history to support it, right? If it were one or the other, if it were logically necessary to have this kind of immunity, then fine, you have this, structurally it is implied. Or if it were like supremely policy wise necessary, or in terms of very, very helpful or very, very useful, then maybe even you can make a purpose of this argument, even though we're supposed to be in the originalist frame of mode. But it's not a good policy. It is not necessarily required, and there's no good history to support it. That's why you have to point to things like Youngstown and Fitzgerald, and even the case that you cite, Marbury versus Madison. That is not a criminal immunity case. That's just applying normal separation of powers considerations. And in that case, striking down an act of Congress, that happens all the time, right? That happens as a matter of course, and that's not immunity.
All right, can I try to simplify this, or do you want to go?
Yeah, I'll give you 30 seconds, and then we're going to go to the judges.
There is no difference between saying you are immune from criminal prosecution under this law and saying you have a challenge to say that Congress was not allowed to regulate your conduct under this law. At the end of the day, they both result in you can't do that. You can't charge that crime.
Self-defense immunity.
It's the same thing.
Self-defense immunity. Is self-defense immunity?
No, it's an affirmative defense.
So what's the difference? It results in you not being liable. So what's the difference?
It's not an as applied constitutional challenge, which you know, and you don't get interlocutory appeal. So it is categorically different in both ways.
But in the case of, like, let's say a public protection defense that you're going to raise, right? I'm raising this defense that my conduct, let's say as operating as a police officer and shooting this individual, this was authorized by law, right? I would raise that, and the court would determine, well, was this cop actually authorized by law to do this shooting on the job? That's what they should have done here. The difference is, so if you want to strip away the semantic difference on immunity, let's just talk about what is the result of these semantic difference, right? The result in my case is you still have separation of powers concerns, right? If there's some application of law or the law itself that conflicts with the president's operation of law, you can absolutely raise that. But the difference is, in my case, you can assess whether the president's conduct itself was legal.
No, you couldn't, because that's what interlocutory appeals mean. You bring the charge, the president says, I have immunity, or I have an as-applied challenge, whatever language you want to use, it doesn't matter. And then the case stops and it goes up on appeal on that point. So you never get further conduct if there actually is immunity, if it actually is the case that the Constitution forbids you from criminalizing that act. You would absolutely not get to the thing that you just raised, but you know this because
sure, you could. No, that's not true. That's not true. You could have interlocutory review, and in the context of take all the facts as alleged by the indictment. indictment and have interlocutory appeal on that while preserving your ability to fight it in trial. So there's absolutely nothing inconsistent with
But you're
having-
not going to proceed in
So I'm
parallel.
gonna actually linearize to get you to acknowledge that it would not be inconsistent to have what I have and also interlocutory review with with deference to the facts as alleged in the indictment while preserving the president's ability to argue more vigorously and present more facts on trial. There's nothing inconsistent. There's no contradiction, correct?
No, but
Okay.
the issue is that they don't happen on the same timeline. You ask for interlocutory appeal, the trial stops. It goes up and it comes back down. And if you were immune, the trial is over. So if there is immunity, you never get to the question that you're
That's
asking.
one of the problems in this case.
Can I ask a
One of the
question?
problems
I need to ask a question just for my own sake here, real quick. You're arguing procedure. Is that what you're arguing right here with the appeal process? It's going to go up and then down.
Yeah, we're getting super autistic about a really, really narrow lawyerly point about what immunity is.
I just wanted to make sure
isn't.
I understood what was happening right there. You're arguing about the okay. Cool. I'm gonna let you respond, Pisco, here real quick. I'm gonna give you 15 seconds, and then we are going to judges for second time. Go ahead.
One of the big problems in this case is there wasn't further factual development or briefing on the kinds of communications that were happening between the Justice Department and the president, and they just basically said all the communications are immune, and they didn't give the prosecution or the government a chance to further develop that. That would have been nice. That would have been nice to do. Besides, like running the gun, if you're really talking about modesty here by the judges.
All right, let's go to Charlie. You're going to be first question. Everybody gets one, judges, because we're running low on time here. You go ahead and lead us off, Charlie. All right, unless you don't want to, then we're going to go to iCal. You got one. All right, and guys, try to keep y'all's answers under like a minute and a half for these.
I love this. This is a lot of fun, dude.
Good.
This is a really awesome format. I love it.
No, I'm enjoying it tremendously.
Good. I'm glad you're having fun. I like it. Good. So go ahead and we'll let you start us off, iCal. I saw that.
This is
the
closer
fear
to
face.
academic debate than I usually see on Twitch, so this is fun. Okay, so I'm thinking about. I hate to like move out of strictly judicial stuff and into politics, but it sort of connects because I remember the discourse on Obama's phone and his pen about how executive power like ought to be limited so that he can't
Biden's?
do that kind of stuff. No, Obama. Obama
Okay.
back in the day said, I have my phone and I have my pen. And he was referring to executive orders. That was after he lost Congress. He had a trifecta. He lost the trifecta. He wanted to continue his agenda through executive orders.
Okay.
And there was a lot of discourse at that time about how wrong that was. But then also, there was that recent what do you call it? Truth Social post that Trump put out just in the last couple of days, saying that trying to extend his power even further, not just against the other two branches of the federal government, but also over states. He said that states are merely agents of the federal government. You can look it up. It's something he said very recently. So this expansive perception of power seems to be growing, and I just don't know aside from impeachment, are there any checks from any branch of government or the states that can limit presidential power?
Absolutely.
And I
It's
think
a great
Ryan and I
question.
agree. Ryan and I probably agree on the terms of the presidency that we're both worried about the expansive nature of the presidency. I just don't know why, if we both agree on that kind of basic premise, why he supports this decision, because it seems to encourage that if what we care about is the outcome here.
So it's a great question, and to answer you, Pisco and I agree on this. I've talked about this a lot. We're both concerned that the executive branch has become too powerful, and I think that's a fair concern to have. The check on an executive order like that one is the courts, because we're talking about criminal prosecution of the president, right? That is one check that you could have on the president. But for what the example you're raising, the president has an executive order that exceeds his authority. The check is the same it's always been. You go to court and you challenge it. And because you challenge it, then, when the states go into court and say the president can't do this to us by executive order, I don't have a crystal ball. I bet they're going to win if he does that. And then it won't work. So that's the check that exists on that power.
I think it's a bit bizarre because I don't understand why it is that the courts can even question whether the president can do anything, right? Like, if all of this is about establishing a president with vigor and with energy, an energetic and vigorous president, right? And the argument seems to be like, if the only Federalist citation in the majority opinion is to that line from Hamilton, which is generally that the president should have more energy and vigor, which I agree that the Constitution set up a powerful president. But that same kind of incentive-based argument can be applied to the regular power of judicial review in Marbury versus Madison. And to be honest, we all know, and the people around the president have argued that Marbury versus Madison was wrongly decided. Project 2025 puts the judiciary in its crosshairs. At every stage, this court seems to be giving up more and more authority to check the president's action in terms of judicial review. We just recently had the decision in terms of nationwide, or I should say universal, injunctions. And at every stage, Trump is walking into courts with the Trump versus United States decision and trying to claim not just more immunity based on criminal stuff, but also in terms of injunctions and what the courts can do. So I'm very, very fearful of this decision that is being weaponized by the Trump administration, basically to further erode Article 3 checks. And soon we're going to have very little check on the presidency. And I think we're already there. I mean, like, he's doing what I take to be obviously illegal firings. He's obviously illegally, unconstitutionally freezing funds that Congress has the core exclusive powers of appropriations. And the courts, sometimes they're weighing in, but more often than not, this Supreme Court is giving him all the deference and all the checks and refusing to hold him to account in ways that he should be.
Go ahead.
Sorry,
just go ahead.
Just to point out that Pisco is completely far afield from the actual issue that you guys are deciding whether this was a correct decision in the immunity case. What Pisco is talking about are broader challenges in the judicial system, and whether or not Trump has immunity has absolutely nothing to do with whether a court, which is ruling on whether his executive order is lawful, will strike it down or not. They're completely separate issues. And again, I just want to flag that the reason we're going down these politics wormholes is because Pisco doesn't want to do the structural argument. The structural argument is the point.
This is bad faith. I have to interrupt you because I'm going down this route because the judge asked a question and said, I know we're moving up off the judicial aspect of it. I want to talk about politics. I'm going to wait for him to put his earphones back on. Ryan, I'm going to get an acknowledgement from you that I'm just following the track that the judge asked and that I'm not avoiding jack shit. And so this was a very cheap snipe. And I want you to acknowledge that I was just answering the concern that the judge was raising. That's right?
I think you took a narrow question and you ran as far and as fast as you could with it. And you ran as far as fast as you could with it because talking about politics broadly is useful for your framing of the case. It's useful for your argument that Trump acts in bad faith, but none of that actually matters for the thing that the judges are looking at, whether this decision was rightly decided. I think it's a good tactic. I'm just pointing out that we
are going to run far and fast to the next judge. Grid, you got a question? Go ahead.
Yeah, and I hope you guys can answer this relatively quickly. So, and basically, I've listened to both arguments. Both arguments were well made. However, my question is, what it seems that both of you are pointing out is that Congress is basically ceding its power to the executive branch and the judicial branch by not actually using its power of impeachment when necessary. And therefore, this argument of immunity and whether or not the immunity should be conveyed should never have happened in the first place because we have an impeachment process in place. I'm curious how you would answer that because it seems like more and moreover, Congress is not doing its job. The courts can only do their job within within their realm, and therefore, if Congress isn't going to do their job, then the president has to rely on whatever means necessary. And I don't care who's president at that point. And I'm really interested to see how you guys answer this.
I'm eager to answer that question, really, because unlike Ryan, Mitch McConnell certainly thought that there's such possible things as an unconstitutional impeachment. And the basis given for why Mitch McConnell chose to vote down the charges from the House in terms of Trump's second impeachment, where he was impeachment, was precisely because it was unconstitutional to do so. And on the one hand, Trump was arguing during that impeachment proceeding that it was unconstitutional for Congress to have that proceeding in the first place, that they had to dismiss, and claiming that the way to have accountability, and Mitch McConnell also argued this, for Trump's actions was to have a criminal process. And so I agree with you that Congress definitely didn't do its job in holding Trump to account after the after the second impeachment. But yeah, that's a huge problem. And Congress, but another way that Congress has and is trying to regulate the president's actions is by passing neutral laws of general applicability that it is standard fucking fair in this country that no man is above the law. And so when Congress passes neutral laws of general applicability, like it's a crime to do briberies, it's a crime to obstruct justice, it's the presumption over the course of many years and over the course of centuries really was that these crimes apply to the president's conduct too.
Right.
So I agree with you that impeachment is the primary method for controlling the president. I disagree with Pisco's characterization of what I said. He asked me a hypothetical earlier that said, if the legislature said it's unconstitutional, would it be unconstitutional? Okay, yeah. I said they're the ones who get to decide. So when Mitch McConnell, who is in the legislature, takes a position on that, that's unsurprising to me. They're the body that gets to decide that, and he's whipping votes on that exact topic. In Pisco's hypothetical, he said that everybody was passing an unconstitutional impeachment, which in fact is not what happened because Congress decided not to do that. In terms of the gridlock effect, and this is well beyond the immunity decision, but it's just a point that I think is important to reference. Gridlock is good. We have a limited government. If Congress can't pass a law, then maybe they shouldn't pass a law. And maybe the lesson we should take away from all of this is that we should be suspicious of presidents who are trying to end around Congress just because they're gridlock. There is a solution in the Constitution to what happens when Congress is gridlocked. The answer is they don't do anything and the states take a stab at it. Our problem today is that almost all of our decision making is done at the federal level and we've minimized our states inappropriately. So yeah, there is gridlock in Congress. Yeah, presidents have abused that to extend their executive authority, but no, that doesn't have anything to do with the question of whether or not the immunity case was rightly decided.
Charlie.
I wanted to defend myself on the notion of this impeachment stuff. You were asked a question about whether an impeachment could be unconstitutional. So I'm asking you to get in the head of a legislator in a presumptive impeachment proceeding, and the charges from the House are, yeah, this isn't a case or controversy. This isn't a high crime or misdemeanor. Would you, as a senator, in that kind of bogus impeachment situation, would you take the position and vote no because it is unconstitutional? It's unconstitutional.
Yeah, of course, because in that case,
that
case, I would be in the body of Congress that's charged with making that determination.
As an observer, you would say that too.
As an observer, I might say it, but my opinion wouldn't matter. Yeah. What happens is, if Congress votes and says this impeachment is good, then it's good. If they vote and say it's not good, then it's not good. That's the end of the story. So yes, a Congressperson will have a view that matters on whether or not an impeachment is constitutional because they're the ones who get to decide it.
And you would have a view on it, right?
But my view doesn't matter. That's the point I'm making.
Let's hold on. We're gonna go to Charlie, and then we're gonna right after y'all answer Charlie's question. We're gonna go to closings, and we'll start.
Okay.
But go ahead, Charlie. Go ahead. What you got for us?
God,
Yeah, that's how I feel.
I don't know how to phrase this question. I mean, if you had to have a primary source of why you think president having criminal immunity is constitutional, unconstitutional, what would be, what would you select as your primary source, your main body of evidence? The document that best supports your position.
Article 1 and Article 2 of the Constitution, which lay out that Congress has certain powers, the president has certain powers, and there are certain powers that are given to the president that do not overlap with the list of powers given to Congress. And that's why they can't regulate things that are in the core and exclusive power of Congress. And I would point you to that decision from 1870, but I think that Article 1, Article 2 are the ones that really carry the weight here.
All right, Pisco.
Okay.
I would point first to the impeachment judgment clause with respect to bribery and the fact that it anticipates criminal prosecutions on bribery, which relates to things we're talking about here, and for treason, which are all things where the mental state and motivation are key to those kinds of prosecutions. So that's the best textual source. And also the best is the evidence of absence. The fact that in Article 1, Article 2, Article 3, there is no text of an immunity clause that there is with respect to Congress. Like, there's an immunity clause for Congress and there's not for the president. We should read into that. And then finally, the evidence of absence with respect to the conversations, right? There's no conversations during the founding era that discuss, oh my God, well, should we have criminal immunity? This is such a bad idea after a revolution over a king. And so the evidence of absence plus the impeachment judgment clause, and then ultimately that it's not necessary, it's not logically necessary it's not logically necessary to the operation of Article 2, and we operated most of our history without it. But yeah, the best sources are within the Constitution itself.
All right, let's go to closings. Y'all each gonna get 3 minutes. So I'll start with Pisco since you were the nag on this this debate, I believe. You get to go first on this part, so go ahead, and you got 3 minutes starting whenever you start speaking.
There is no historical documentation that shows that the original public meaning, that the public understood, that when they were enacting Article 2 of the Constitution, that they understood what they were doing was giving criminal immunity to the president. If there was such evidence, don't you think Trump would present it? Don't you think that there would be newspaper clippings and like, oh my God, these anti-federalists, right? These anti-federalists who were talking about how the Constitution should not be ratified. Look at this document. This document is giving criminal immunity. There is no evidence that the original public meaning understanding of Article 2 implied this kind of criminal immunity. There was, at that time, there were parallel immunity provisions in state constitutions that were excluded in the Article 2. There is the limited immunity clause that exists for legislative officials that's in the Constitution itself. And then over the course, it's just not necessary to think as a structural matter that you would need this kind of criminal immunity. Both Barrett says it's shorthand, that immunity, she puts it in scare quotes, that what she means by immunity is what Ryan is referring to here, like this kind of interlocutory appeal and normal separation of powers principles. That's just not what is meant by immunity under the normal notion of what immunity is. If that's all that is meant by immunity, then fine. Ryan should just give up the game and say that the majority is wrong on the evidentiary rule, that they're wrong in terms of the scope of what's going to be provided, and that the court should be checking to see whether the president's actions here, actions which are like obstructing the official proceeding with respect to January 6th and basically sending his goons to try to take over the country, that the court should have some semblance of checking whether that's legal before they rule as a matter of separation of powers, that Congress can't target the president over that. And I think that it's very telling on the impeachment matter that Ryan, I don't think, has a very satisfying answer for why Congress should be allowed as a constitutional matter to inquire into the core and preclusive authorities of the president in an impeachment matter, and then afterwards he's liable for prosecution on that impeachment matter, but not for legislation. If it's core and exclusive, then surely Congress can't touch it either with an impeachment or with an indictment based on a congressional statute. My name is Pisco. You should follow me at Pisco's Hour on YouTube and Pisco on Twitch. And thank you so much for the debate. I had a lot of fun.
Thanks for being here. All right, Ryan, you got 3 minutes whenever you start.
Always fun to argue with Pisco. He's well-informed and worth a follow. Check him out. I don't have a channel even a fraction of his bandwidth, but maybe you'll follow me too. I started this conversation by talking about the pardon example because it's the clearest one and it's the easiest to understand. And it is totally clear on Supreme Court precedent. It is totally clear on the logic and the structure of the Constitution that Congress cannot criminalize the pardon because they lack the power to do so. And that's the only question really here. If Congress lacks the power to criminalize something, they can't send you to jail for it. Therefore, you are immune. That's the issue. Now, we've talked about a lot of different things, but that core structural issue is really undisputed. And that's why I'm going to point you again to the fact that at oral argument, the lawyers who were trying to oppose Trump, who were trying to put him in jail, said, Justice Gorsuch asked them, did you agree that there are some core functions of the executive that a president's conduct that Congress cannot criminalize? And he said, yes, you cannot criminalize certain core functions. And that's the whole ball game. That's immunity right there. Even the lawyers against Trump agree on that. And for Pisco to be right, the lawyers who were prosecuting Trump have to be wrong. The Supreme Court has to be wrong in this case. And as Pisco admitted, they also have to be wrong in another case called Nixon v. Fitzgerald. And I guess they have to be wrong about the pardon case from the 1870s. The structure of the Constitution is clear, and it's enough for you to decide the case. The policy, everything else, doesn't matter. The Constitution protects our liberty through the separation of powers and through limited powers. We might not love the outcome in a particular case. We might think we would have preferred it to go differently. That's not the point. We're building a Constitution to last and to protect our liberties into the future, and that's what the Supreme Court did in this case when they recognized the limitations on Congress's powers. Thanks. Have fun.
All right, judges, just go ahead and DM me who y'all think won privately real quick, and then we'll come to y'all in a second. Tomorrow, guys, if you're here and y'all like debate, we're going to be debating and discussing Russia-Ukraine post-Alaska summit tomorrow. And then on Thursday, we're having another one of these. It's going to be over whether or not comic book Superman would join ICE. It's going to be pretty entertaining, I think. And then Friday, we're on some sort of dating show. I don't really know the details, but that'll be good. So check it out. It'll be fun stuff. Maybe somebody pops my balloon. It'll be a great time. Anyway, that's what we got going on. Oh, it's Saturday. We're debating the shrimp welfare guide, and I think that'll be fun. If you know my positions on beef. So it'll be good stuff. I am excited. While we wait, anybody got anything they got going on that you want to shout out? What's your exciting news?
I'm going to be talking to Drew Pavlov again soon.
All right.
That'll be cool. You guys should stay tuned for that.
All right. And
I'm supposed to be chatting with Counter Connor sometimes this week, so I'll figure out. It hasn't been scheduled yet, so I'll let you guys know. And if you're doing shrimp welfare, I did a shrimp welfare debate on Wick's panel, so you should look at the video either on his or on my channel and see what tactics worked and what didn't.
all right,
Ryan, are you coming to DebateCon?
I just learned DebateCon existed when you asked the question, so probably not.
Okay.
But
Well, I'm having an event there. I'm hosting an event, an opening for DebateCon, and you should come to my event, and then maybe go to DebateCon because it's gonna be really rad. It's in Nashville.
hit me up in DMs. I would very much like to come. We'll see if it can work.
All right.
Yeah, I'll get that from Gibbs.
Fantastic.
And,
We'll make it happen. We'll get the networking going. All right, I got the results, and I know some people got hard out, so let's hop to it. We'll start with Grid. Who do you think won and why?
I'm going to be honest. I think Ryan took this one almost from the word go. Thought his arguments were really pretty well framed. My problem with Pisco is you just kind of said the same thing over and over again, and you kept leaning away from the fact that impeachment is the actual control, and so therefore, honestly, immunity is not needed. Although in this case, obviously, it was used, which is weird and a completely different argument. So I had to go with Ryan. Ryan made a better case. He made and I didn't. Yeah, I actually came into this really not knowing a whole lot about it, other than that immunity and impeachment seemed weird bedfellows. So, all right, that's it.
All right, let's go to ICAL. Who do you think won and why?
Okay, so I'm still trying this whole debate. I was still trying to struggle with, normally when you make an argument, you try to like prove uniqueness and brink and things like that. But the key thing you need is a link. Yeah, I need to be linked to like where this legal theory comes from in a way that I can understand as a layman. And I still had a hard time. I think the most substantive thing that I get from Ryan in terms of the link as to where this immunity comes from is the fact that Article 1 and 2 like spell out two different branches, and that therefore like maybe one doesn't tread on the other. That I understand the argument about pardon power, but I also know how pardon power is spelled out in the Constitution. That gives me a direct link, and I never saw like a direct link to specific lines in the Constitution that gave out that immunity. It's just this sort of vague claim about the structure of the Constitution, which kind of reminds me of Roe v. Wade reasoning, where they had to go to three different parts of the Constitution and create this sort of Frankenstein structure in order to make their argument. It's sort of, maybe that's not what it is, because I don't understand legal theory enough, but that's what it seems like to me. And so, but also, Pisco doesn't give me anything either. I get some sort of like vague references to court cases, but I don't see any like specific link, like hard link in the Constitution saying this is the power that that the Constitution gives in order to check the president in this particular way for prosecutions and things like that. I also don't understand the argument that Congress can't regulate, because in my mind, this debate isn't over Congress regulating. It seems to be about over the courts regulating, right? Because that's what the case is responding to, is all these things going to the court. And they're basically saying the courts have no authority over here too. So if Congress can't regulate and the courts can't regulate, I still don't understand where those powers come from. But because I don't get these hard links from either side, it's very difficult for me to decide. What I have to do now is I have to go to presumption. Who has the burden of proof? And like in my mind, there's two things that tell me where I think the presumption should be. There's this idea that immunity clauses do exist in other parts of the Constitution, but they don't exist with regards to the executive branch. I didn't hear a really good argument for that. And the second one was this. Well, maybe even it's an aside, but this argument that gridlock is good is really in tension with the argument that the executive needs to be a vigorous executive, right? Which is the argument for immunity. Like, it seems like this gets rid of gridlock, doesn't add to it. And because we're not deciding a legal issue, right? Like, at one point, Ryan said, to support his argument, he said, well, this is a Roberts decision. This is what Roberts said, right? But if we're asking whether or not it was wrongly decided, we can't then say, because Roberts it's circular, it seems to me, to appeal to Roberts' thinking if we're deciding ourselves whether or not we think, I mean, we can't say SCOTUS is the one that decided SCOTUS. And so, because for those reasons, especially for the immunity clause statements that were said, I have to give presumption to Pisco's side. So this is what I think, though, because I'm really disappointed in not being able to have these links. This is what we call a low point win in academic debate, where I'm not really happy with, I'm really not confident in my decision because of that. But because of where I have to give presumption, I've got to vote for Pisco.
All right, last but not least, Charlie. No pressure.
Oh yeah, the tiebreaker.
Fuck. Well, so I personally take Pisco's side, in the sense that I think that a president having criminal immunity is crazy and scary and bad and freaks me out. But I do feel that Ryan was slightly more persuasive, because he seemed to stay. There were a couple times, Pisco, where I think that you brought in other but related topics, but it wasn't maybe I'm not very quick. It wasn't immediately clear to me how it was relevant to the argument at hand, which was a little bit frustrating. And I do feel like Ryan stayed more on topic. And so for that reason, sorry for being like a real jury and going off of vibes. I would say that Ryan won.
All right. Well, that was a good one. Exciting stuff. I hope to have you all both back soon. I like, we need more lawyers. The lawyers always seem to do well in these debates. So, I like that. So, yeah, hopefully you all come back. We'll get you on more of these. But congrats to Ryan. Thank you for coming, Pisco. Thanks to everybody. I have a hard out as well. So I'm going to rate out to somebody. Anybody streaming for a while?
I'm streaming for a while.
I'm on Twitch, but I'm also on YouTube. And I can be up for a little while.
All right. Well, I'm going to raid one of y'all here.
Some shit.
Thank y'all so much.
Shit about everybody.
Yes, thank y'all so much, guys.
Later, guys.
Y'all be good. Appreciate it. Thank you.
Thank you for having me on.
It was a lot of fun.
This was fun and confusing, but
Ryan,
fun.
I'll get your information from Gibbs, and I'll hit you up.
Grid, how do I raid on YouTube?
Absolutely, would love that.
Grid, can you
Talk
tell
later,
me
guys.
Can you tell me how to raid on YouTube?